Telstra and the Australian Performing Right Association, or APRA, was an important High Court case which helped to define the scope of the term to the public in regards to copyright infringement. APRA owned the copyright in a number of musical works. Telstra played some of this music to their customers while they were on hold. APRA argued that this constituted a breach of their copyright in the musical works, as it infringed their exclusive right to broadcast the work to the public under Section 31, subsection 1A of the Copyright Act. The Federal Court held in favour of APRA, stating that Telstra's use of the music did in fact constitute a broadcast to the public, and therefore infringed APRA's copyright in the works. Telstra disagreed with this ruling and appealed to the High Court. The High Court case rested on the interpretation of the term to the public, which was particularly difficult to apply in the circumstances, as Telstra was only broadcasting the music to a select group of customers who called them. Justices Dawson and Gaudron contended that whilst a broadcast to the world at large is obviously a broadcast to the public, the situation becomes more difficult in a case of broadcast to a limited class of persons. Thus, the justices turned to case law to determine the scope of the phrase. In the case of Duck and Bates, it was held that the representation must be other than domestic or private. Harms Incorporated and Chappelle & Co. and Martin's Club added that when determining if there has been infringement, one must observe whether there has been injury to the author. Thus, profit or commerciality of the broadcasts are both important factors. Case law and legislative history also suggest that the audience must be one which the owner of the copyright could fairly consider a part of his public. But the most decisive case considered by the court was Rank Film Production Limited and Colin S. Dodds. In that case, the owner of a motel used a video cassette recorder to broadcast films into his guests' rooms without payment to the copyright owner. In this case, it was held that the transmissions were made in public. It was irrelevant that the individuals were receiving the transmissions in private circumstances, and that the broadcasts were only to a small section of the public, as the motel was open to the paying public and operating for profit. Similar to this case, the High Court found it irrelevant that Telstra's broadcasts were only received by a small section of the public, as the facility was available to the public at large. Furthermore, the fact that Telstra's broadcasts were made in a commercial setting meant that it could not be considered domestic or private, despite the fact that the audience might be in the privacy of their own home. Lastly, as the broadcasts were made in a commercial setting, the owner of the work's copyright is entitled to expect payment for the work's authorised performance. Thus, the audience is one which should be considered the copyright owner's public. As such, it was held that Telstra's broadcasting of musical works was made to the public. The High Court therefore held in favour of APRA, dismissing Telstra's appeal.